Session today, and we're going to begin by hearing consolidated petitions of Lloyd and Mark James Clay and Jeffrey Allen Inmates versus the state Robert Butterway respondent. Each side has an hour after the petitioners conclude on their initial presentation. We'll have a short recess and then reconvene. Now, I understand that Mr. Minerva, you are going to begin, and you have passed for 5 minutes. Mr. Steele will follow with 15 minutes, Mr. Carter with 15 minutes, and then Ms. Calvin for 6 minutes. You may proceed.
Thank you, Ronald. Good morning. I'm Michael Minerva, and I'm one of the counsel for the consolidated cases. Our office represents Mr. Polina, Mr. Perry, and Mr. Garcia in these consolidated cases. I'd like to introduce arguing counsel this morning, Chris Spalding from the Public Defender's Office in Miami, Scottsdale, and CCR South, and Tim Stoller from CCR, the North Region, and Chuck Hoffman from our office, who will be arguing motions for clarification. When we file these motions, the state file a response questioning why we are here. We are here, of course, to protect the rights of our clients, but more importantly, or just as importantly, we are here to protect the Florida Constitution. We are here to ensure and to make this court aware of the balance that has traditionally existed in the difficult problems of adjudicating death penalty cases, especially in post-conviction, and the fact that in light of the death penalty reform act, that balance is seriously threatened, that the balance of the power among the 3 branches of government is threatened because the legislature has overstepped its bounds in passing the death penalty reform act and has intruded upon the domain of this court in not only making rules, but in interpreting and enforcing the Constitution of the state of Florida. With a 20-page document, the death penalty reform act has overruled about 30 years of death penalty jurisprudence by this court. It has attempted to do that. It has taken virtually every decision of this court enforcing the due process and equal protection rights of death sentence persons in post-conviction and thrown them out the window, and in effect has threatened a total chaos on the system, because nobody knows how those provisions will be interpreted. The gloss that was on the rules and the statutes before is all gone. Not only that, by precipitously passing this act with no provision for the right effective date, this court had no choice but to stay the effect of the act until these things could be sorted out. During the process of the creating this statute, the executive and the legislative branches have, in effect, told this court, or tried to tell this court, that due process under the Florida Constitution doesn't matter. That the right to be free, the right to have equal protection of the law doesn't matter. There are obvious flaws in this legislation, so that these flaws were noted and repeatedly talked about during the process of the enactment. Even the legislative staff summaries caution that there were serious problems here in this legislation. Among them, most significantly, separation of powers. The legislation plainly says it is enacting rules, which is the domain of this court. And there's a reason that rules come under the jurisdiction of this court, because this court regulates the process of the judiciary and protects the rights, the constitutional rights, not just of the majority, but of the minority as well, and particularly unpopular minorities, such as people sentenced to death. It is for this court to keep the balance true. The legislature responds to the will of the majority, that's the problem. However, the court must strike the balance, and with this act, the balance is out of kilter. Now, in addition to the separation of powers and severability problems, which will be explained, the pipeline cases, there are 85 people in direct appeal who are supposed to get lawyers automatically, somehow, all at once, and meet a filing deadline which keeps decreasing as every day goes by. There is a one-size-fits-all filing deadline in this South for pipeline cases. That is, people who are on direct appeal whose cases have not yet been decided on direct appeal. About 85 of them. All at once, these people will be dumped into the system with no mechanism for attorney counsel, yet an absolute inflexible filing deadline of January 2001.
Has there been any steps taken by any of the CCRs to attempt to go into practice to get counsel appointed?
I don't think there's any mechanism that provides for that, Ron.
So the answer to my question is no.
To my knowledge, no, and they will address that.
Has registered counsel been appointed by the counsel?
To my knowledge, no.
Yes, you have used that a lot of times.
Thank you, Ron. I would like to add one additional comment, that in all of these, the rules that you will hear later and the legislation, there are these common flaws. Equal protection is violated because the rights of death sentence people, strangely enough, are now fewer than the rights of other people in post-conviction. That the amendment that in a successive status, a person is unable to raise a freestanding claim of innocence, unable to raise a freestanding claim of innocence of death, that there is a elimination of the right to raise issues of fundamental changes in the law that occur after the initial petition is filed.
Listen, let me ask you a question, since you have, even though it's extended time, it's still limited time, and you all have divided it up here. As you know, this court itself has recognized that there are many practical problems out there, and that especially with reference to the processing of the post-conviction claims in the trial court, that there is at least an impression that a lot of those cases that have gotten lost or fallen through the cracks, insofar as bringing them to final resolution through an evidentiary hearing or other appropriate hearing. And this court has been at work with reference to trying to correct those kinds of problems, and has been active functions as long as I've been on the court in that regard. I wanted to ask your view, because you're well experienced in the system, that one of the common themes that seems to come out from the commissions that we have to look at this, and really from the legislative response too, and that is trial court docket control. And I wanted to ask, while maybe at the podium, whether or not, however this all ends up shaking out, that would you agree that trial court docket control is an essential ingredient in any reform of the process? And just ask you to give us the benefit of your experience and your views for that.
So you
understand why I'm asking?
Yes. And there are several responses to that. One is that there needs to be flexibility with the statute and the marriage rules, for example, totally leave out, and they leave out child court.
The judge supposed to agree doesn't need to be docket control.
Well, yes, Your Honor, there needs to be docket control, but the question is, where does that control come from? Does it come from this court? Does it come from a set of rules? Does it come from the local judiciary and the local state attorney and the attorney general? And
I'm asking you in a sense to set aside some of that. That is a rule that should come from, that's the single instance that should come from this court. Would you agree that some form of more organized docket control at the trial court level is needed? For instance, a number of the judges on this court have expressed to you that perhaps we could almost either create a presumption or almost a mandate that go ahead and do an evidentiary hearing for the great majority of post-conviction motions in justice, because a large part of the lost time was really, in a sense, seems to be wasted if you reverse for an evidentiary hearing, seems to occur in that 2 or 3 or 4 year period between the time that it gets to the trial court to decide the case for Maryland, and it goes to the appeal up here, and then finally goes back down, for an evidentiary hearing. And I would say that's part of docket control. Is that whether or not we beef up or increase the presumption in favor of evidentiary hearing. But some devices to try to focus on what is going on at the trial court level, because it seems to me, at least in my experience up here, that that's where the most problems have occurred of cases falling through the cracks. Is one at the trial court level. Not to fault anybody in particular, but that's what's there. So, I'm just wondering whether there might not be a consensus or some broad agreement on the need for some form of docket control at the trial court level.
I think that the consensus among us is that the automatic evidentiary hearing at the trial court level would help that, and there's not really substantial opposition to that. That might be one way to do it. One of the problems is that we all tend to fingerprint, and it is a very complex process, and it is such the awesome finality of it requires careful attention to every detail. So while control is good, flexibility is also required. And what we're saying here is that all of these mechanisms that are before the court right now are way too rigid. So the idea that has been espoused, I think, by at least 2 justices of the court, Justice Lloyd and Justice Cariante, for the mechanism you're talking about, would probably work and would eliminate the back and forth of the trial judge making the ruling, denying the evidentiary hearing, and then it's coming up here, and then it's going back. And in that process, the case is getting shifted, getting lost, cross assignments from one judge to another, from one set of lawyers to another set of lawyers. But this is also a problem that has developed as a result of all the changes that have come about in the last few years, in which the system itself has not stabilized. And so every time the legislature comes up here, they make sweeping, drastic changes, and nobody can adjust to them. And by that time, the rules have changed, and now they're changed again. I'm way over my time. Thank you very much.
Holding this is the court, both on federal court and as reservoir, busy at times. I intended on discussing let me follow up on this question that Justice Ansel posed. I mean, don't we, regardless of whether you're hitting at that table or this table, have to agree that we got time enough, that we've got people that have spent over 100 people that have been on death row since before 1985. And part of this problem is in the area of case management, in that we've got out of your court, we got the Jones case. It's stuck there for 9 years in the circuit court with no one doing anything. We've got after it was sent back by this court for an incompetency here. We've got violate, in which there was the killing of a police officer in 1979 in Dade County, and in which when they went to post-conviction, it was there for 7 years on post-conviction and then sent back by this court for an evidentiary hearing because the CCI lawyer wouldn't divulge who the witnesses were at the hearing. Now, it seems to me that when looking at this problem, what I'd like to hear from you is what have you done in looking through your list of cases to see what the problem is and how these new procedures would fit within those individual cases to get those matters heard?
I feel it's two different questions. Turning to the first one in terms of caseload management and docket control, I agree that, and putting aside the corporation powers argument, clearly this is the court that has the authority to do that. I think what we have to keep in mind is that these cases are serious cases, and there's a presumption when people get together in a committee that they look at something, why has this sat here for so long, overlooking the fact that you have busy trial judges, you have serious cases. The other thing to keep in mind in terms of a lot of the cases that are currently coming up before the court is that because of the sweeping changes due to the legislature, really over the course of this entire decade, beginning with Rule 3851, after that was from this court, taking it from 2 years to 1, then the advent of 3852 and the breakup of the three CCI officers, and all of this completely paralyzed the system. And so, when you're looking at cases that are coming up to the court now, you really have to factor in the fact that most of those cases, the times have been told for, in some cases, a number of years because of these significant sweeping changes. Part of the problem is that, as Mr. Minerva alluded to, when this court has changed the rule, or when the legislature enacts a new statute, before the rule of the statute gets a chance to kick in and see if it works, there's another new rule in effect, or there's another new statute repealing the rule.
But as a general rule, where do you think the responsibility should lie for moving a case? Once a post-conviction motion is filed and a statement filed and answered, who next has the responsibility to set it for a hearing or whatever?
I think it's the court, it's clearly the court, and I think that answers the question that there needs to be some form of case management. Clearly, and we haven't taken the position that there shouldn't be. I think the position is, however, that you can't have such a draconian kind of rule as is in the DCRA because it does not allow for any local control by a particular judge, given the particular circumstances of the case, to set hearings in an expeditious fashion. Now, this court really has not seen any of the mid-90s cases that were under already ruled because they were so long. I know personally, I go from Scottsdale down in Miami to Lauderdale, Palm Beach all the time. And so there are a large class of cases that things are moving much more expeditiously. The problem is that when all these new rules have come out and all these new statutes have come out, it's completely swept the rug from under the feet of all the other cases. And so we're in the catch-22.
So once you go to the status conferences, then what happens? And you just said you go from status conference to status conference.
Well, what happened is, for example, you go to a status conference, the judge will say, what's the status of the public record issue? Judge, we have this agency outstanding, this agency outstanding, this agency complied, okay, let's start a hearing on that. So we put a hearing on that. We go to that hearing, we wait for the record, and the case moves in a orderly fashion. The days of things being filed and just sitting are long gone.
There's nothing in the past where that deals with the issue of a case management by the court in the way of allocating resources, and I know from being in this field that being able to get reliable case management information from the 67 counties because of the vast diversity of technology, lack of technology in those counties. We have no ability from this point to make any effective case management decisions. So we just recently installed case management, and I know that from Iraq, there's an indication that as far as these cases are concerned, maybe the Commission on Capital Cases should have some case management. But I know you're here with on some other issues as well, and I think that this has had the effect of drawing our attention to the efforts of the court and the efforts of the legislature to deal with this part of the time. I'm going to the sales on death day. Excuse me, how is the sales on death day? Not very good. And often do those folks to get out of those cells. That's 2 hours a week. And how often do they get the trial? I believe it's once a week, twice a week. And that's a pretty tough adjustment. I understand that, Your Honor. I also want to add a little, okay, so I think something that I've talked about before the court and how to become the leader in terms of defending lives. The standard for any evidence in hearing is essentially a presumptive standard in favor of evidence in hearing. The record has to exclusively refute the allegations. Time and time again, this court has been faced with erroneous claim denials, where the state has taken the position that affidavits are required, witness names are required, trackers are required, and that has never been the law, and they continue to make that argument, and judges unfortunately choose to side with the state's argument, and therefore we find ourselves before the court 5, 6, 7 years down the road, but look at it, but states that clearly have had an evidence. That gets us to what we're going to talk about later this morning, and tomorrow, which is because of what the legislation is doing, and shouldn't do. The last good duty that is given for conviction. You have everything on the table from the very beginning. Not that you've got one witness somewhere that you're going to divulge it from later on. When you do that, in terms of writing on your program recorder, I don't, that has never been a standard. If they want something that's going to continue, it should be a standard. I don't agree, no. I don't agree. What's the way to look at it? Have the evidence? No, not have the evidence. The allegations that are made in a motion have to be factually sufficient to go in a hearing. The name of the particular witness is not, that doesn't in any way conclusively refute or alter in any way the granting of evidence in hearing. And so, and there's never been a problem in terms of when a hearing is granted, these things are going to take all the time. It happens on a routine basis. The problem is that the state has taken a position that, as a bottom line pleading requirement, all of this information has to be put in the motion, and that's just simply not the case.
So why wouldn't it be a good idea, though, to aid the court in determining whether an evidentiary hearing would be appropriate, that there being exchange of witnesses and exhibits prior to that matters the hustling? Because I see, too, as I see the hearing, it's sort of an all or nothing. Because we see pleadings that are confusing, and they're long, and they're confusing. Not all of them, but we see that. And on the other hand, as a requirement that says if you don't, dot every I and cross every T, you're going to be out forever. But doesn't there have to be, can't there be some balance between the two extremes so that the trial judge is aware of what it is that's being contended and to make an intelligent decision that this isn't a re-litigation of what happened at trial. Mm-hmm. Because all too often, some of the claims sound like they're re-litigating that. So why can't there be something more than is required now, even though we have said the law doesn't require the listening of witnesses? But does it make sense to wait for after the evidence is hearing? Because again, in so many cases, for whatever reason, these have been denied, and then it's too late for the judge to say, well, if I'd known you had that witness, you'd deal with it.
Well, I mean, certainly I think from the perspective of the challenge in this case, if there's going to be some kind of a balance that it's got to be struck by the court, not by the legislature.
Yeah, the legislature has, whether this can stand, but they have said that although they have promulgated rules, it says that it only stands until this court revises the rules, and it doesn't say that the rules have to mimic the statute. It just says they have to reference the statute. So the legislature has invited us to pass rules that wish to have some guidance, but they be a little bit more explicit and more focused on minimizing delay.
And certainly they need to be more flexible because, for example, if under the DPRA, if I put the wrong address or spell the person's name wrong or something, that could be not fully said and the petition is just gone out the window. And, certainly any balance that's struck needs to be struck on both sides. So it also needs to come forth with fully factual allegations and affidavits if they have them, and all the documents to support their position as well, and so it's not a one-sided process.
Is there a flaw right now in the fact that if this time limit that would require the post-conviction process to begin while the appeal is still pending, that there is, and you're supposed to be able to get your public records done at that time, except for exempt records, that there is an exemption that the state can claim for their records, that the records that you rely on for your post-conviction, and that they, right now, the way the statute is run, those can't be produced until after the appeal is over.
That's correct. Excuse me, in the focal, the court made clear that investigative files or that a case is active for public records purposes until the direct appeal is final. And so therefore, under the due procedure, which Ms. Bowling can address in some more detail, the records that we do rely on are hidden until the direct appeal is final, which of course is sometime after the post-conviction process is supposed to be completed under the DPRA. And so it really is sort of a plan so that we can get some records, but really not the important records. But that's until file guarantee and open file policy. Well, I mean, certainly I would certainly don't want to speak on behalf of the state, but given the fact that the direct appeal is not yet final, and given the reversal rate in capital cases, I don't know that the state is going to be that happy with turning over all their investigative files, given the fact that there's a pretty good chance of a reversal, either for retrial or resentencing. And given the police agencies have instructed to stop your file. And then it's one time. It would solve all of the problems. It wouldn't solve privilege problems, other kinds of problems, which I know Ms. Bowling is going to address in a bit more detail, but basically I know we've talked about things that are important to us, and I know they calibrate and that's on your list as well. I know that we give an opportunity now to talk about. I know you follow a little bit out of this issue. So that's the thing. I'm one of the reasons I'm here to answer your questions, and so I just briefly want to address the separation of powers issue and the due process violations that we hear in the Death Penalty Reform Act. I think the pleadings that were compiled on behalf of my office, the CPI North, and by the public defenders really explicitly demonstrate that it's clear this court has exclusive jurisdiction to enact rules of procedure and regulate the conduct of lawyers. How about the broad parameters of setting the timeline as far as from a broad perspective of what's the interplay between the legislative branch and the judicial branch and those during the nature of the collateral proceedings? Well, I don't think, given Rule 3050 was initially created as a procedural mechanism by which a defendant indicates his or her right to habeas corpus under the Constitution. And so any time restriction which affects a constitutional work cannot be spread out as a statute of limitations or statute of repose, whatever they want to call it, because we're dealing with something that's constitutional in nature, a procedural way by which our clients have to vindicate their rights under habeas corpus. And so there's a definite distinction between this scenario and some of the cases that were cited
by both the state and I think by Amazon. They haven't replaced the limitation program requiring the filing of a petition within a year. Yes, however, that is not an absolute limitation. What the 1 year rule was an accommodation based on the fact the majority of the court view that because death penalty defendants get state paid counsel, that the time limit could be consistent, that the rule comment made it very clear that was premised on a number of conditions that have to be met. Number one, full funding. Number two, based on the then governor's promise that no warrant should be signed throughout the initial state and federal process. Under the DCRA, if a motion is filed outside the statutory time limit, a death warrant is issued. And a death warrant can also issue on the denial of previous release of a state and appeal. So we're not as much complaining about the setting of the time limitation as we are the fact that there's no discussion whether the court for it. Correct, and I also think it's within this court's clear jurisdiction to set up any time limit for. We continue to think, as the court, Justice Hardy's administrative order, which we'll talk about later on, so it would be wise to go back to the 2 year time frame. But even if we know whether it's 1 or 2 years, that's something that this court, the careful study, needs to address, not the court or legislature. Similar to the legislature has no business telling this court when it has to adjudicate an appeal. So much of the act is procedural in nature that it's impossible to sever the procedural from the substantive, and so therefore the act as a whole has to fall.
Let me ask you about this time period, the guilt class. Aside from the constitutional issues as to whether because it's a form of habeas that we're looking at, what understand the legislature's desire to speed up the process. Could you address whether the dual class mechanism is an efficient and logical way in which to make this process more efficient and less prone to delay?
I don't think it is a more efficient way. I know, again, Ms. Spalding was supposed to talk more in detail about the dual class, but since you give me the opportunity, I'll just share my 2 cents. I certainly don't think, given the nature of some of the clear constitutional problems that are raised by the dual class process, including privilege problems, any-time privilege, Fifth Amendment problems, all of that, that's one aspect that is prevalent in terms of just a more practical notion. With the reversal rate that has been historic in Florida, by this court on direct appeal, 50%, 60% of all the time and money that's spent by the PCR officers getting records, litigators, investigators, is that your consideration by the court? I think it's that the legislation wants to appropriate the money to do that. Well, the legislature hasn't appropriated any money for the PCR, but I think they recognize, and the court has indicated that the big system of law could have to be a well-funded system. But would that be something we should be concerned about? I certainly think so, because the legislature, when all of this was in the works, indicated that the money would just be flowing in terms of being able to finance this kind of undertaking. And of course, what turned out was that CCI was not going to get any of that money, and then all of it essentially go to the legislature. So one problem is the levy has not been cut. And in terms of some of the other problems, of course, you've got this warrant problem. You have a number of problems associated with the practice. Again, I'm really going to refer to Ms. Spalding, who is prepared more to address that subject side. I certainly need to You briefly mentioned dual classing, and it certainly has an attractiveness and could very well be the way in the future. How, in your opinion, can it be tweaked? It has practical problems. The court possibly could see some tremendous practical problems with dual classing. But when you pull the floor and you that dual classing was coming about, how would you say that it could be tweaked to accommodate it? This is a perfect time for you to get paid in. I also advocate my role as King of Florida. I really would prefer to misspelling I was going to think that although it's attractive perhaps in the abstract sense, it cannot work. I know that it has not worked in a number of states which have tried it. They abandoned it, what they have. I believe Missouri and Arkansas. And in the states that did initiate it, I know they have since had to tweak it on a number of occasions to get it to work, and it still hasn't, I believe, sort of like California. And there's a backlog of several hundred cases in terms of finding counsel, and so I just don't think, given the system that we have, as imperfect as it might be, that system really needs a chance to work itself out without being constantly interrupted by rule changes and statutory changes and breakup of officers and running out of money and death warrants and things like that. So, I haven't figured out addressing some of the due process problems with the Act. I'm going to let Mr. Fellows take over. I know that a lot of the due process problems with the Act are also, from our perspective, associated with Morris's rules, so perhaps I'll address them later.
Let me just finish this down. There's been a lot of talk about the Jones standard being altered for newly discovered evidence. I haven't seen, maybe I've missed it, or this material. What effect either the Act or the rule would have on the constitutional Brady, Giglio, Henry claims, which has a different standard anyway than Jones? Do you see those as having to, because they derive from the U.S. Constitution, that those claims cannot be covered by this Act, no matter whether it's upheld or not?
Those kinds of claims certainly raised in an initial release of the records would remain, that's federal law.
The substitute.
It's accepted.
For 4 years, you found out the prosecution suppressed the key bit of evidence. They put it, someone took it home, didn't bring it back. You want to raise that. Would the Act accept the Brady standard of materiality?
I mean, it wouldn't necessarily affect the Brady standard. What it would do, though, is push that analysis path so many steps down the road, because the way that the standard is set up for successive petitions in the Act is that you have to show a constitutional violation in order to even raise a Brady, exactly. And so there's really nothing in there in terms of how all that's supposed to work. Of course, the other major problem with getting rid of Jones is that there's no provision for raising a successive claim that involves sentencing. There's no provision for raising a successive claim related to a change of law. And one other thing I did want to touch on in terms of the Act is that it completely eviscerates the court's decision in Taylor, which emanates from due process regarding incompetent clients. I did note that the Florida Bar proposal did include a section on that, but the Act is completely devoid of that. In fact, under the Act, if the client is incompetent, it would appear that that client would be completely out of recourse to seek post-conviction relief. Again, I prefer to make the comparison.
Morning, Tim Carter from the Office of Smart Dialogue. I'm going to talk mostly about equal protection problems with the statute, and picking up in the sphere of our class of some of the due process problems which define your questions in here in any kind of unitary review of your system. There are three broad categories of equal protection violations that would be involved for you to adopt any kind of unitary review. That is the invidious discrimination against people sentenced to death when compared to people sentenced non-capitally, even for a capital offense. There is the disparate treatment of people receiving state-funded counsel under the statute, and there is the greater disparity of treatment for people who receive state-funded counsel under the registry, as opposed to one of the regional counsels representing them.
It's passed that under Chapter 27, all defendants in post-conviction receive state conviction.
It is not a fast and empirical fact. It is a statement of the law that they are entitled to it.
That's what Chapter 27 says.
Each state that they are entitled to it just as well as they do not, of course, all deceivers. I represent people in the state without funding from the state of Florida. Or by appointment under the federal court. Certainly not the case that everyone in the state is provided state-funded counsel, nor that they need state-funded counsel. Some people have retained counsel.
But under what you do, even under the act, everyone is in the same death row and is in post-conviction is entitled to state-funded counsel.
Absolutely. I believe the state of Florida has created the due process liberty interest in counsel, and that it has the appropriate constitutional protections that go with it. It is an absolute right. There are specific considerations, and only in those circumstances can the right to counsel be taken away. So not only is it statutory, we think that it has constitutional practice as well. With respect to initial post-conviction review, whether under the DPRA or under the Morrison proposal or the violate proposal, there's a systematic disadvantage imposed on everyone sentenced to death. It's simply not faced by people sentenced non-capital, whether it's for a traffic offense or for a capital offense. It's a touched on public records problem that this statute and the rules are designed to protect all relevant information under a blanket public records exemption for law enforcement files. With respect to your question, Justice Wells, about an open file policy, I think you're right. So we have to look back historically at how these cases have operated in the past. And when we do that, we'll see that the probability of an open file policy working in the past is so remote that I think it's not really worthy of any consideration in a rulemaking situation, unless there's an enforcement mechanism that's tied to it. And so far, we just haven't had that.
What safeguards would you want in? Suppose the court said, all right, it's going to make the rules. What safeguards would you want in relative to dual classes since it was deferred 2 years?
Well, I guess I get to pass it around to this man. Dual classing, as you say in other states, unitary review, doesn't work. The first state to adopt it was Missouri. Missouri was the first state to abandon it. The second state to adopt it was Arkansas. Arkansas was the second state to abandon it. Probably the biggest attempt to implement unitary review was in California, and it was an utter disaster. Hundreds and hundreds of cases sat in the California Supreme Court, and it was to this day, because they could not implement that system because of the demands it places on the pool of lawyers available to take it, because of the demands it places on the court. It is simply an impractical system.
So you're saying that this is not good in the legislature to have the benefit of free program?
I think that the statute itself is an opportunity, and it's rulemaking that has the opportunity to see failure. However, no, I don't think so, because the constitutional rights that are protected behavior, which is in itself, of course, a constitutional right, can't be protected under that system because of the public records.
Could the legislature, rather than taking an absolute position that it cannot be done, we offer you this opportunity to tell us what you would want in if we said it will be done.
I think that again, I would prefer to Ms. Barnum in particular, because she's very prepared to argue this more than anyone. But there would have to be some mechanism for dealing with, for example, the problem that was putting the Sixth Amendment privilege that exists between counsel and his client. on any kind of retrial, resentencing, against the client's constitutional right to free habeas corpus relief, which, ironically, he needs to enforce that Fifth Amendment right. In this state, we have a 50% reversal rate on direct appeal. So if you have this real trial, any person sentenced to death, the decision-making process he goes through is, well, I'm sitting here, I have to decide, am I going to, who am I going to trust? Am I going to trust the lawyer who represents me in the habeas matter, or am I going to trust my direct appeal lawyer?
Is this a constitutional issue? I guess the only other place now that has clear sanctions of the criminal nature to this case on the right case is Texas. Has that issue been challenged and taken to the Supreme Court of the United States?
I'm thinking of the, I don't know that the Supreme Court has ruled on it. There is certainly the Morris versus Classy decision, which is somewhat tangentially related, and that it discusses whether the relationship between an attorney and a client at trial is constitutional and protected. Well, you said that the right of habeas is altered because because the attorney-client privilege is law. But that is just now post-conviction. In fact, when you make a decision to claim ineffective assistance of counsel, you are waiving your attorney-client privilege. Explain how it becomes a different constitutional issue when that waiver must occur while the direct appeal is pending. Does it infringe on a defendant's right to appeal because now they've got to do the track, they've got to take the habeas at the same time as the direct appeal, and therefore as a condition of habeas, they've got to waive that privilege. Where do you succinctly state where the constitutional issue arises with the dual track mechanism when it is pushed back to the appeal period? Again, I see the particulars of how you deal with that problem by the court of law. But in terms of the violations itself, yes, that's what I can. You're putting as you said, you're putting the two attorneys against each other, and the client is placed in the middle. So the reason it's a greater problem in Florida, a Sixth Amendment problem, is because you have this 50% reversal rate. So I am forced, as a person sentenced to death, with an appeal coming before the court, before non-conviction and sentence has become final as a matter of federal law. I am forced to say, well, I am going to have to roll the dice and think, well, maybe my case will not be remanded to the trial court at 50% of the law.
But let me ask you this. We have set standards for process in death penalty representation. We have established courses for judges to take and require them to take those courses. We would certainly hope that those issues would be addressing the high reversal rate and bring it down.
Well, some of those provisions have been in effect, I believe, for a couple of years. I think that certainly the new rules with respect to counsel have not. But last year we had something like a 70%.
Yeah, but those cases were found several years before the order dealing with education of judges and counsel cases, and before there has been the census.
And that was the point that we tried to make these departments. We have, this court has done so much to improve the process, and that is just one example. What would the process look like if those reforms were allowed to operate? Would it work as quickly as the legislature wants it to work? We simply don't know.
And maybe we never will.
Maybe we never will.
But we do have to deal with what we have at this point in time.
Right, and what I'm saying is that the opportunity to to see if those reforms would work without compromising the constitutional rights of my client.
Let me get another issue. You talk about the equal protection and the discrimination between capital defendants and others. How could that be remedied? Would we just say that the present rules apply only to both capital and non-capital, or do we raise the standard for non-capital?
I think you say that the present rules that you have in effect establish the constitutional floor for habeas corpus relief in this state.
Are they premised on establishing the constitutional floor?
Some of them will. For example, the Hogg case, which requires flexibility, which requires that people not be arbitrarily denied access to habeas corpus relief because of something like a mailing error, which certainly in this statute you would do. I think that Jones establishes the constitutional floor with respect to innocence or sentencing relief, or and that Richardson establishes the constitutional floor for newly discovered constitutional violations. All of those things would be swept down when you need to impose the same requirements on non-taxable people. Simply put, the quality of justice in this state is premised if you were to do that for all taxable and non-taxable defendants.
I think the 2-1-3 CCI brief and public defender's brief is the inflexibility of the rules. If some equitable tailoring is built into it, would this cure a great deal of that?
Those kinds of equitable considerations, yes, they would. They would cure a great deal of the problem. Obviously, the flexibility, such as requiring that if something is violated because of a problem with the mail, that has to exist. And if you said it to be told, as in the Hogg case, that would be a problem. If, for example, the due process right that you recognize and feel in the drama was present if a lawyer failed to file a petition in the timely way, we've seen in a shocking number of registry cases. Yes, that would solve some of the problems.
For instance, innocence has to be coupled with something else. I gather now that the rules to be addressed to the same point. There might be a constitutional problem with that, but if these type of things were ironed out, then there are too many of them trying to mind out.
I think that's what we've talked about so many, that it becomes a question of can you completely rewrite this statute in the guise of saving it? And I think that it would just simply not look like what the legislature intended.
But they've been invited out, the legislature's invited the court in draft rules, right? And so that could I will accommodate these issues and these issues and that's all further on. Maybe change it.
Speaker Francis Lee, Specialized Director, he asked you to adopt rules that would create a system that implements the intent of the legislature, not in terms of the nation's clear, but to work-life practice, a system that has the integrity of a professional wrestling match. They have invited you to do that, but they haven't, even that open an invitation as I understand it. Can you adopt rules that would move these cases quicker through the process, certainly the kind of case management that you talked about so far, could achieve that without diminishing access to justice by making innocence not recognizable in the state of the court?
So what do you see in the statute that it says that we're bound by the rules that the legislature adopted?
Well, there are only two sections of the statute that say unless some later adopted rule of court comes into place. If I'm not mistaken, those are sections 6 and 8. But I'm not quite certain of that. So, as I said, it's not an open invitation. There are some classes of cases over which the legislature said it does not want you to adopt contrary rules. And even taking Chief Ross's brief, if you look at the conclusion of that brief, he says, what I want is a statute of limitations, some kind of time bar. And if you are going to adopt rules to implement whatever you're going to adopt as rules, make sure that that time bar, that absolute bar on the ability to raise these claims outside of the period that decides for you effectuates that.
Your time, the light is on you.
I can miss that.
And Ms. Collins, you have been referred to twice.
Well, I think you actually answered most of the questions. I'll just try to address a couple of points because I think most of it has been covered. First of all, in response to Justice Clark's question about what could be done to make a parallel tax system work. Essentially, I think the right to counsel is the single most overwhelming problem. And that essentially, as Mr. Sutton indicated, you have two models of states with similar size just ways, but also have used a version of the parallel tax. There's California and Texas. In California, where they insist on having qualified counsel, they still are spending enormous dollars because they simply can't enough correlate.
The basic failed because the country was unconstitutional.
Because I'm saying what you think.
Because the system was unconstitutional. It would fail as there was inadequate funding and it turned into an administrative nightmare.
I think the two issues go hand in hand. I think to make any constitutional rule of procedure that would implement a parallel tax procedure would have to, as this court did in reducing the crime claim in 3851, have to be conditioned upon the provision of qualified counsel. I think that has to be an absolute prerequisite. And secondly, on a system in which there is enough flexibility for this court to engage in a kind of equitable planning that Justice Clark is talking about, so that if those obligations are not being met, this court has the means to fill the claim.
But has the system been ruled unconstitutional in California?
No, it has not. Obviously, California
has the stimulus to ensure that the due process right, and the fact is that the legislature has not adequate funding or adequate resources to not come forth to represent you.
Right, and what is happening in California is that there are 4 years away to get the county of appeals to get appealed. But you're right, the court has at least held the line as far as they have not gone the route of Texas and appointed unqualified counsel. But what we're concerned about is we're on the brink, though, of doing that here and following the steps of Texas, because at least the governor's budget right now does not reflect funding for any additional CCR positions. Instead, it's currently the expectation of the executive and legislative branches to the entire increase both as a result of federal taxing and the DCRA will be assumed by registry lawyers. And the fact that crucial before anything goes forward with this to represent
the CCR is
is that we have already had twice as many mixed federal habeas deadlines in Florida since the registry went into place as there have been in Texas. And if all of those cases are dumped on the registry as it stands, we will have irreparable harm to our clients. And I think this gets into the real issue that we've raised concerns about. And there's a difficult balance in terms of assuring qualified counsel, whether you can do it through quantitative experience standards, whether you can do it through qualitative standards, or as most experts agree, what you really need is adequately funded professional defender officers like the CCR.
Have you proposed what you believe to be the necessary budget to the legislature?
And my appetite of CCR
have
done so. I'm with the public defender's office. But I assume the
public defender's office submitted budget to take into account responsibilities of the public defenders under the plan?
I don't think that it will have, although I'm not involved in that side of things, I don't think that the effect on our offices at the Director Trial level is going to be that significant. It's more in this because I assume they detected the kind of our concern is that we're on the brink of this point where it looks like that there's an intention to have the additional caseload assumed entirely by the registry. And it's very important for this court to be aware of the problems that have arisen with the registry transfer, and I think that Justice Hansard emphasized in his concerns in the Aguilera case the integrity and reliability of our system depends on the quality of counsel and on this court's vigilant supervision. And this court has been vigilant in its supervision and actually to continue to be so, and that the most significant red flag out there for the trial process is to ensure qualified counsel.
But it seems to me that if what you're talking about, and what I hear you talking about, is lack of funding.
Right.
But the place to do that is by the legislature is presently in session. And I think, and that's the reason I'm interested in knowing what you know about what has been requested and not requested in order to take care of this thing.
Yeah, I know we're at the beginning of the session, and I'm not confident to speak to that, but it will go hand in hand again because it's also the importance of having standards that are flexible enough so that which is not the case in DCIA to strip this sort of its authority to exercise equitable tolling in the event that qualified counsel can't be found. Those two issues go hand in hand. That's our concern. So this court needs to have the flexibility to toll guidelines to administer any procedure failure to take into account the overriding issue of ensuring that there are qualified counsel.
Now, you said there is not a problem, or you don't know the problem with the appellate strategist. So that you don't, there is a provision that requires a different appellate public defender's office in a different district to handle the appeal.
Right.
I would assume that there has been some symbiotic relationships between the appellate divisions of the different districts and the public defender's office. Can you address whether that would cause a disruption in switching cases that would say go here to the first district and to the second district or the third district?
Right, and absolutely, yeah, I mean, that has been our position, that I think certainly in our appellate division, we endeavor to work very closely with our trial division as the case comes back for resentencing. The appellate lawyer tries to continue working with the trial lawyer, and I think that has generally worked very well and resulted in positive outcomes.
That will not be done under the person's proposal.
So now the appeal would go to, if it was one that was proposed that was tried by our own office, would then have to be signed out to another office. And so you wouldn't have that kind of
the problem if the case is tried in Jacksonville and the public defender in the second speculative following the appeal, you would still have that same problem.
And it varies from office to office because other offices, unlike in my own office, you only have two counties, whereas some of the other appellate divisions are concerned that very specifically in the Selena cases that the immediate implementation of DCIA means disruption in established attorney-client relationships. We have cases that have been fully briefed that are pending before this court, which under DCIA, technically the office that did the appeal would now have to withdraw, another office would have to step in and assume responsibility for the case under the cross-circuit conflict provision. And we've argued that that provision is unconstitutional, particularly for the people.
You were referred to as having some knowledge about the code dual tracking system. If we are of the opinion that we should at least try to give this dual tracking system a try in the state, or maybe something not quite as draconian as you think this particular piece of legislation is, where would you say in the system could we begin at least the post-conviction process short of a final, or is there a place, short of the final determination on the direct appeal, that we could begin the post-conviction process?
I think certainly it couldn't, I mean, if you look at the options between the DPRA or the Padavano's proposal, certainly I think it's essential that that time not start until after the filing of the initial brief, because post-conviction counsel must be able to know what issues have been raised on direct appeal at a minimum before you could proceed. And would that entail some kind of change to the public record portion of the file? Yes, it would. I mean, because you would need to make those records available. The other issue which Justice Hollander asked about was the flip side of that, which is the privilege issue, because the defense would likewise be required to disclose confidential information, work product information, rather than attorney. Specifically, when you ask what constitutional rights were implicated, under United States v. Simmons, defendant exercises one right can't be conditioned upon giving up another right. So at a minimum, if that were to be the case, you would need some sort of mechanism in place so that any of that information cannot subsequently be used against the defendant in the event of a new trial and new sentencing.
Isn't that what happened, though, when there is a new trial ordered in post-conviction? All those same matters are out there on the table.
Right.
The trial could just come out in post-conviction. What difference does it make whether it comes out in post-conviction or on direct appeal?
Well, I mean, essentially, you'd be dealing with a significant increase in the number of cases where that occurs, and I think, and this may be more of a policy argument, but you're going to have, I think there are a lot of hidden costs involved in that, and it's a very cumbersome. It's sort of much like Pascal with immunized testimony, like the techniques that had to be used in the Iran Contra cases of scanning evidence beforehand so that the prosecution could establish that they weren't relying on any of the information that was compelled to be disclosed. So it's very complicated. There's also sort of additional delays further in under the dual class when you have a claim asserted against the trial attorney. That means that the case does come back for resentencing. You can never have the same attorney do the case of the retrial resentencing because of the concept. So those are some of the factual considerations.
Thank you very much. We have heard the petition side, and we're going to take a 10-minute recess. But you didn't believe we could do it in 10 minutes. So the 10-minute recess. All right.
Good morning, Chief of Court. This is Mike Brown on behalf of the state of Florida, with me at Counsel table of Strong for Taxes. Probably the best news we're here this morning is that I don't have an hour's worth of presentation prepared. In fact, I'm really primarily here to respond to the questions, the thoughtful questions such as you asked my opponent. It's our position that the constitutional challenges previously asked fail, that most of the concerns that they raised are simply value judgments by opposing counsel who do not wish to fix and change. But the simple fact is that all three branches of government seem to be in agreement that we do have to change our capital collateral process. We have, which we'll hear later, the Consolidated Reported Remorse Commission. We have, of course, the Death Penalty Reform Act of the legislature. We will be moving forward and we will be cutting delay. And of course, this court will be mindful of the constitutional rights of all parties to those proceedings, and also will see to it that these proceedings and these changes are implemented in a fair and equitable fashion.
Let's go up to our thinking for a moment and make who the public records of the region. Under the way that the new act reads, the public records part of this procedure is moved up into the direct appeal process. Now, the other side in the argument this morning was talking about the fact that that is going to have a detrimental effect on the defendant because there will be certain records that cannot be resolved. Now, isn't it correct that because of Brady and because of our discovery that we should interpret the public records matters as going forward with an open file policy which reaches down into the investigative agency.
I think it's clear from all your questions that Brady has always superseded public records in the sense that it's always been an independent basis for the preparing of records, and that state attorneys or other police agencies have obligations both in the public records and in the Brady. And as you're pointing out, the Brady obligation that exists at any time in the proceeding.
Now, what's the state's position on if this is moving, if we go forward on a real talking system as set forth in the statute as to the discovery of public records that are involved in law enforcement investigation files? What's the state's position on that?
Well, all I can say is that prior to the tolling of the provisions of the Act, the state attorneys had begun to send out their notices to, some of the state attorneys had begun to send out their notices to the law enforcement agencies, and we had not received any objections to it. It was somewhat early in the process, but the state attorneys themselves seemed more than willing to comply with the statute as it was written, which they were reading to me to say that the records.
But there have been some assertions to the concept of that, I remember.
Well, our opponents are assuming that the state attorneys or other law enforcement agencies will be making objections based on the purpose case. That will not be right.
So what do we do with Coker?
Well, I believe that the purpose of Coker was telling the state attorney that during the course of a post-conviction proceeding, he didn't have to turn over his records that related specifically to the defense in that proceeding. In the context we would be in, the trial prosecution course would be over, the appeal would be pending. The state attorney really wouldn't have any records that pertain to the appeal per se, so it would go back to the investigative matters that Justice Lloyd has been discussing.
And what should we do with the exemption, or does the exemption have any inmates?
Well, I guess there is another public records exemption relating to lack of finality or pendency on appeal. That's something I would assume the legislature considered that when they enacted the statute, and the fact that moving the post-conviction process further goes to take priority over that matter.
So we'd have to, what you're saying is we'd have to consider that exemption to mean that finality means when the death sentence is imposed, which is when the CCR is appointed, not when the appeal is complete. That's correct. Okay, so that would be, so is it expressed or would we be rewriting the statute to do that?
I think it would be implementing the legislature's intent, given the fact that they've said public records occurs and needs to occur at this point.
So it would be upholding the constitutionality by considering the statute to change the language of the exemption, even though the legislature didn't change the language?
I don't know that there's a constitutional question here.
Well, the constitutional question would be due process, but if the very records that Postconviction Counsel rely on in order to raise the various claims should not be had until after the appeal.
Like I said, that hasn't been quoted in those terms, but yes, if you do change the exemption, it would be necessary to carry that out.
But at the time we adopted 3.85 subsequent to the legislative change in 1998, we said that the rule was ancillary to post-conviction capital proceedings under 3.851, and I was assuming that there would be a basis in adopting a rule that would do what the legislature has now done under 119.19 and have it, if the time period moved up, but have it have the same effect as the prior rule insofar as the reach of discovery is concerned.
Okay, I would imagine that informal review would be an option for any agency that felt, for whatever particular reason, the records were so sensitive, the disclosure was not appropriate at that time. That's something that the judge could validate. I think what this is part of, and perhaps nothing just against it, there's a common theme definitely between the legislation and the Merit Commission, which is that we just have to start the post-conviction process early because we're losing too much time.
But the Merit Commission starts it after the appeal is final. And my question, because we certainly have handled a number of post-conviction cases, I'm trying to envision an actual hearing being held, an evidentiary hearing on an ineffective assistance of counsel claim when the direct appeal is still pending, and what types of hypothetical questions would have to be asked, because sometimes an ineffective assistance of counsel claim is based on the failure to object, and we don't, without knowing how this court will dispose of the direct appeal, whether they'll find that a point was procedurally barred because it wasn't objected to, whether it was fundamental error, whether it was harmless error. How do you, as in a real-life sense, have a meaningful evidentiary hearing while the direct appeal is pending, regardless of the issue of how many cases is reversed or affirmed? Isn't the opinion of this court usually the starting point for evaluating what kind of, at least as to the ineffective claims, ineffective assistance claims, what will shape that the post-conviction claim? So how do you see the practical part of this working? And my concern there is that we don't, assuming if there are these constitutional impediments removed, either by statutory construction or otherwise, we don't put ourselves in a system that will do what this court doesn't want to do, what this process don't want to do, because it will double their work, and what the legislature didn't want to do, which is perhaps further delay the process.
Well, I see, although I have come to the same initial thoughts that you did, I'm taking this, but I think in a way we may have more half-hearted hearings on the effectiveness, because the way the cases come now is the appellate team will come down, and for instance, the appellate attorney will raise a certain number of issues and just put an assignment procedurally barred. So by the time we get to the hearing, that will state how the ineffectiveness claims are done. In other words, anything that from a case of your opinion is still contradicted and preserved will become a badge of ineffectiveness in the period of time. That may or may not really be relevant to this man's performance. I mean, if you have someone who just reads the transcript and who doesn't know what's going to happen in the appeal, but the collateral attorney can decide for himself and herself, I think, whether that performance meets the circumstances and what the deficiencies are. without knowing what the appellate result is. In fact, it may be more accurate because it won't be skewed by things that are later passed.
But if this court hasn't yet decided whether someone is harmless beyond a reasonable doubt, then how does the trial court evaluate the ineffectiveness if we haven't yet determined what the outcome of the case is going to be?
Well, this is the purposes of post-conviction hearings that will go on before the appeal goes. The court will have to assume that it's going to be affirmed, but the court will have the entire case approved. The court will then, the judge who presided over the trial, and his determination of lack of prejudice, is usually made in a vacuum of his own determination anyway. In this course of this court's appellate opinion, you will have discussed certain issues, but your opinion wouldn't necessarily be informative about how important this particular.
Do you think it would be a better hearing because of this system as opposed to just a quicker hearing? You're actually saying that you think that it will work better without this court having yet made a determination as to whether the death penalty is being affirmed or reversed, or whether the sentence is being reduced to life or not?
I'm saying it should be less result oriented because, ever since we've had serious others, we've constantly had a line of cases that say you can't re-raise appellate issues and you can't re-raise appellate issues as an effectiveness claim. So if you have someone who reviews the trial transcript and he raises what he or she perceives to be the deficiencies of counsel, they do that simply based solely on the case law, and they don't do it based on kind of reading theories in this court's opinion about whether or not, an issue covered the court or whether or not you would have reversed it or has been objected to or whatever. It's simply the case.
But the ineffectiveness is what you do at trial. It's not like theories. It's that it's theoretical until this court makes a decision as to what, in fact, happened at trial, resulting in affirming or reversal.
It's the test that the trial court will define is not an appellate test. It's whether or not the result of the proceeding, i.e. the jury's conviction of the defendant or sentencing of death, is affected by the defense counsel's alleged errors. And the judge can make those determinations without knowledge of the appeal. The only part where this court's appellate role comes in is ineffectiveness of the appellate counsel, which is supposed to raise differently, and it's specifically tested so that is raised after the appeal goes. That's just the question.
Would the state agree that you can't treat capital and non-capital defendants differently to due process purposes?
Well, I know that when this court shortened the time under 3.51 originally, there was an equal protection and a due process argument that sentenced individuals were deemed disadvantaged. And this court addressed that concern and pointed out the difference in position between capital and non-capital defendants, i.e. that all capital defendants are represented by counsel. And I think to the extent that that argument is being represented here, that is still the answer. That we spend millions and millions and millions of dollars on funding and ensuring representation for everyone on death row.
But that doesn't say that a raising of the standards benefits with the constitutional law as well. Does that have anything to do with counsel?
So the standards for constructive motions could certainly be applied equally to non-capital cases.
But they're not. And I think that's the issue. As I indicated earlier, what do? Do we make them apply to all capital or to non-capital cases? The burden of proof is heavier in the capital cases under the tax and business cases than it is in non-capital cases.
7%.
Is that a problem?
So again, I think obviously it makes more sense to expect that defendants who are represented by counsel will have the ability to comply with court deadlines, will have the ability to file a full fledged motion, and will have the resources which are necessary to comply with the legislation.
So that's one thing, getting it to the court, but when you raise the standard significantly and make a diversion between capital and non-capital cases, doesn't that have some equal protection implications?
I'm not sure if that was raised in the trial court opinion, but again, this legislation was modeled on what the U.S. Congress did which the U.S. Supreme Court approved in Federal versus Pickett. And every death sentence individual throughout the country who wants to file a successive federal petition will have to meet the same threshold which we have now set in our statute.
It doesn't on that though, you agree that the statute is drafted removes the defendant's ability to make the so-called freestanding claim of innocence that is separate from a constitutional right. And so the example would be DNA evidence exonerating the defendant because it is tied as it's drafted to a constitutional right. You agree that as drafted, it removes a death penalty, a death sentence defendant's ability to raise a freestanding claim of innocence. And even though that may be what is modeled on the federal statute is federal habeas for constitutional rights. The state has other obligations because we're the primary place where the rights of the defendant in state court are protected. So how do you see that problem, equal protection and due process, removing the ability of the defendant to make a freestanding claim of innocence without having to tie it to a constitutional right? In other words, a witness saying, I was lying, he didn't do it, this guy did it, DNA saying, the other person did it.
Well, so that type of claim will always be tolerable in the initial round.
No, I'm saying this is only discovered, they only come forth 3 years after the fact.
Well, the actual innocence is a threshold, and if you cross that, you get into court. So if you meet that standard, then what the way to do it, that's like a conscious claim.
You said it said it has a constitutional penalty.
So that's the way that the federal system has been working. So in other words, if you had a Brady claim or an ineffectiveness claim or evidence of other matters of which raise a constitutional issue, you could have them heard on the merits in a successive petition.
If you meet a real simple innocence issue cannot be raised under this legislation unless it is coupled with a constitutional error.
That is the better standard.
Your suggestion to this court is to apply that to all defendants in the state of Florida.
I'm saying it could be. At the moment, it is simply applied to capital defendants, but that would be a lot of problem. Well, we've already had one full round of collateral litigation by this point in time. We do have a clemency process which is designed to pick up issues which the court are not best willing to have aired. I can say it has worked within the federal system since it was enacted in 1996.
But this is the very reason the federal system went to what it did, because what was happening in states were under everyone saying, well, we'll just take care of it in federal court, and federal court was becoming the dumping ground. And the philosophy of the Federal Act is to say, no, this type of litigation must go on in the state court. And doesn't that make it more important because of the closing of the door for federal habeas, that state habeas guaranteed by the Constitution remains vital for those claims such as actual innocence, claim of ineligibility for the death penalty, a violation of a fundamental constitutional right that has retroactive effect, prosecutor and misconduct where there has been actual suppression of the evidence, actual judicial bias such as the court reporter, all those important rights to both in this court jurisprudence, and that are just erased by the act that is before us.
I don't see it that way, because again, we have to remember that this provision comes into effect after there has been a full round of state and federal litigation. And obviously in passing this, the legislature, as well as the Morris Commission, felt that the ground standards for me to set that into a two-way.
Yeah, but even the Morris Commission has the claim of ineligibility for the death penalty and has the claim of innocence without it being tied to a constitutional right. So those are very significant differences, aren't they?
Well, Congress does not have an innocence of the death penalty as part of the federal legislation either. And again, I think those are choices that the legislature can make based on its authority to set questions of law, and based on the fact that there has been innumerable delays in successive petitions in this state. This is a decision that they can make. It's not one that's crafted out of whole craft. It's one that came from federal precedent, which is the Brown Constitution, which has been applied throughout the country.
I recognize that it's your position to defend the House, and you appreciate that. But is it the state of Florida's position that if DNA actually proves the person innocent, that unless it's coupled with constitutional, the state will go ahead next year?
Well, I do believe that this act provides enough procedural safeguards to deal with that, because it has provisions that specifically allow defendants to bring a claim as evidence of that type within, I believe, 90 days of its discovery. And certainly a defendant who has that type of...
How do you read this language? What's the red language mean to you then? It means to me that it has to be coupled with constitutional error. Am I wrong?
No, sir, but again, all the federal defendants who have sought to pass the prosecution have had a claim to couple with their innocence claim, and I don't think that it's inconceivable that a court would come out and have a state process, at least once.
But they've gone through the state process, and that issue has been determined by the state court.
That's true.
That's the rationale?
The best claim that they want to have reviewed could be any one of their claims that could get coupled with the actual innocence to get to them.
I think it's a problem that we're struggling with the same problem that was outlined as long ago as this. That is this problem of dealing with finality and both sides here, the finality of the death penalty, but also trying to come to grips with the fact that that's developed in the 20 years since quit, that excessive motions can become the exception that controls a conviction. And does the state have any other suggestions along that line as to what can be put into a rule? Is the state in favor of setting aside, and we'll talk about it later, I know, but the type of analysis that the Mark Committee proposed to cause successive motions?
I think that's along with the Supreme Court said Herrera, which says it was their expectation that claims about their innocence would be very few. Unfortunately, that hasn't been the case. It's been a cognizable claim within post-conviction. But on the other hand, I don't think they were just naive when they said that, because they believed that through the course of rigorous capital trial litigation, that the truth can be sorted out. And again, we're ignoring the fact that there has already been a prior post-conviction action in the state court, which in all likelihood had an evidentiary hearing, which the claim of innocence would be cognizable and would be resolved, and that would be passed upon by the federal court, both district and appellate, and scrutinized. So I guess, as you say, we're trying to find a way to prove the exception that you would lose in this respect.
But the whole idea of subsequent Brady claim or newly discovered evidence is that because of something not attributable to the defendant, something that they would have wanted to have at trial wasn't available. Brady, it was the application of a prosecution that wasn't for the law enforcement agency, newly discovered evidence, the issue that this evidence could not have been discovered with the exercise of reasonable diligence before, so that we already have that far, that although we had a lot of successive motions, the truth of the matter is very few of those successive motions are successful. But we're now looking at a situation and concern that where the claim is one of actual innocence, that rather than say, well, maybe the system will, maybe there will be clemency, or maybe there will be that, shouldn't the due process rights that are granted by this Constitution, and the right of habeas either way that those claims are presented. So that we don't, while we have maybe abuses that are occurring in the system, rule supposedly says, allows the judge that if it's a successive motion and they find there was abuse, to strike the plea. So we've got that. But they say, well, because we have these successive motions, what we're going to do is make the standard for release so high that even if there's actual innocence, we're going to require the court to ignore it. Seems to me to be the wrong way to attack a problem of delay.
Well, the innocence is a gateway into the court. The court's always going to hear it. I mean, I guess the way that the draft of those kind of things, the power line issue seems to almost becoming more important than the innocence, because the innocence will be there, and that's what the court is doing. That's how we have to read it differently. So, okay, but I agree with Justice Parental that the worst scenario would be if the government could protect all that. I would think that would give you your constitutional Brady claim that would get your hearing on the innocence. That would be your constitutional violation, and that would be your...
But then the Brady standard, is the Brady standard changed under the Death Penalty Reform Act? Does it purport to change it under one? Two, can it do it because Brady is constitutionally based on the power standard of materiality?
No, it doesn't change it. If you have the threshold that once you're before the court, the traditional case law...
So only the Jones standard on newly discovered evidence is changed, but not Brady and Julia, that have to remain whatever they are right now under the civil law.
Mr. McCall, we address the issue of raised the petitions regarding the January 8, 2001 filing deadline and the cases in the pipeline that have in the appellate process and the counsel has been appointed.
Yes, sir. These are the pipeline cases, and as counsel has indicated, there is approximately 85 of them. And they're important, but they can't skew what we're going to do in regard to the entire 367 applications approximately that we have now. Certainly when the legislature set that deadline, they did not contemplate any specific polling by the court, which has occurred. There has been some discussion of equitable polling. I just have to be very careful what I say about this because I spent in the fall court and stated the truth that there are incomplete CFOs being filed in the state, and then I'm sorry, stated the truth that there are incomplete CFOs being filed in the state, and ever since then I've become the father of fair motions, which I'm just a the opportunity of that. But in any event, no agency of government is seeking to cut off this court's equitable powers, and certainly within the course of the transition to this entire system, if this court deems it appropriate that those pipeline cases receive a deadline that's more in accordance with the time every other inmate has, the state is not going to argue that you couldn't do that.
I understand that the cases are being having the counsel appointed at this point by the trial court. Counsel, is that you indicate that that's controlled?
I believe that's controlled. I think there are arrangements for a couple of cases right after the statute was passed, but I don't believe those appointments have gone forward.
It is a good position in that we need to take that matter up on a case-by-case specific basis.
Okay.
Let me move you to the matter we started off the morning, we mentioned the murder about, and that's this part of the statute which now becomes the commission a case management responsibility. What is the state's position on how these cases can be taken? One of the things that occurred to me in the last 6 years on this court, and I've spoken rather than opinions and from the bench several times, and that is that the state has a responsibility in seeing that these matters be timely heard. And what is the Attorney General's office doing in this area of going back in cooperation perhaps with the commission in looking at each case and coming to a determination as to why that case was doing this system. Can you something to do that?
Well, I know that when the Morse Commission first came out, we very much agreed with the recommendations of the Status Conferences to keep the cases on track. That's not a part of the formal legislation, but really what is in the legislation is the Circuit Court's lack of ability to extend the following deadline, which in effect will force the cases to be timely. As I say, our biggest problem is in the beginning. Once we get the fully played motion, we can go from there, and that's not usually where the delays happen in the post-conviction process. The delays are in getting that motion, which literally takes years and years and years to get. And the thing that both the legislation and the Morse Commission agree on is the public record is not an exercise by magistrate or anything excuse not to follow your fully played motion. And if that isn't acted, and if it is fully enforced, that will have the single largest effect on funding.
What I'm suggesting there is that each one of these people around that way have a specific history of those cases. And we will have to accomplish problem that we have on the basis of looking at what has happened in those individual cases to see what the common problem is, and then attack that. And what have we done to come up with that information?
Well, I believe that the circuit judges are still supplying the court with quarterly or monthly reports. Okay. It would be helpful if we received those also, because we would be more than happy to assist the court. The court could have periodic status conferences bringing out in the context of the case, but by region. In other words, with the CCL counsel and the representative of the Attorney General's office in this court, and actually automatically with the judge or the chief judge, just to see to it that these cases are not falling to the past, because I agree with you that is the worst problem. But the problem in the beginning is that no one really knows what the deadline is. I mean, at present, we've been operating with a year from finality, but that's what's told, that's what's extended. The defendants come in and say, under the full court precedent, you can't hold me to a deadline, so I have every single public record. The judges don't feel comfortable something that or overruling that, so they don't. And so it goes off without a specific time limit. Then we have a partially played motion, but again, the defendants take from your precedent. You've occasionally said, okay, because in this case you got records, so you don't know if 50 days to amend, that's taken to be an entitlement of right that will be next for 50 days and an unsettled amendment.
Basically, one of the problems, again, there's plenty of blame to go around, but in public records, you have a situation that if the state takes a position that they are going to make sure all the agencies raise the defendant what was asked for, that would eliminate a lot of the litigation, wouldn't it?
So, in effect, that's what's going on in circuit courts throughout the state. But, again, because we've never really had a consistent rule about the specificity and relevancy of public records requests, we're expected ones where agencies are asked to run 73 names without dates of birth of relevance that no one can figure out.
How long would you say that an average it would take to, if there's reasonable cooperation but some problems, the public records litigation or production to? How long does that take? Can you give me an average?
Not really. I would say that since what kind of generations of cases, I would say the generation that came after the repository is going better than the earlier generation.
Less than a year?
In most cases, yes.
But at least more than 6 months?
I would say so, yes.
And would it make sense to have, instead of having a deadline for the filing of the post-conviction motion being rather appeal is pending, would it make sense to have the public records aspect of the litigation go on while the appeal is pending? Because that seems to be the biggest problem to get to a fully paid motion, and then have, as soon as the appeal, have the deadline be as soon as the appeal comes down, have the motion. That would then eliminate the problem with those cases that are reversed, and it would save the Attorney General's office time in litigating those. But what seems to be the biggest problem in getting to a place where they're fully paid might be eliminated. How would that be as a logical way that would save time, but also would save time in the process, would also be efficient overall.
I think that's what the legislation contemplates.
They contemplate that when you have to file your post-conviction motion fully fledged,
6 months after the initial date.
and so if the best of everything goes on, and if somebody is litigating public records for 6 months from the date to final judgment, maybe you get there, and that creates that tension. And then the problem I see is that, although I understand there's got to be a difference between a cell motion, but the aspect of the fully fledged is what we see is a lot of appeals come up here in summary denials or things that you say, how could the process, why did this happen? Why was this not allowed back then? And I'm concerned that we'll see a host of cases that are dismissed because they're not fully fed, and if that's going to end up delaying things even further, because the fully fed requirements could be that if you didn't attach that affidavit and you had that witness, you didn't fully treat it. And so it's mind-boggling that could create. So if the public, I guess that's what I'm looking to, is not only not draconian because it's not for the defendant, but for the process, it may make the process more inefficient by creating all these other technicalities that you'll feel obligated. Your officers feel obligated. I've got to file a motion to dismiss because of this, but then we end up reversing it 2 years down the road.
Well, I think, to the extent the court will be adopting rules, and we've all recognized by most likely occurring a number of circumstances, unfortunately we'll do it close to the middle after the hearing. At the moment, we have nothing as far as the motions are concerned. And the state can't make an intelligent response to the cell motion, and the judge can't make an intelligent response as to whether or not to have a hearing. So having various timeframes running while this ambiguity is no one. So I would point out though that in defining a fully fledged motion, the legislature took almost entirely from the Morris Commission, and those were experienced judges who regarded this as possibilities, reasonable possibilities for capital defendants to comply with.
What is the state's position in reference to the connection between the public records disclosure and the filing of the initial first fully fledged petition pardon? Obviously, the first obligation of post-conviction counsel is to investigate. Is that correct?
Yes.
And would you assume that public records production would be an essential ingredient in that investigation?
It has become that.
And you wouldn't ordinarily condemn people to file petitions before they've made a proper investigation. Is that right?
Yeah, that's right. And
so what would the state team do with reference to public records production connected to the obligation or deadline for filing that first motion?
I think the legislature has set them out already, and the process will be beginning very shortly after imposition of the death sentence, which will utilize what has traditionally been dead time. We'll have the appointment of trial counsel. Trial counsel will have access to the public records in the repository, and that will enhance his or her ability to comply with the filing deadline for the period of time. Even if the legislation puts it as early as it possibly can, and we think it's workable as it's doesn't work that out.
Well, I guess my question to you is that would you expect a petition to be filed before the public records disclosure is completed?
Well, public records have gotten to replace discovery, and we use the two terms interchangeably. The fact that a defendant may not get every public record that he or she perceives as relevant.
Let's say you represent a defendant, and you're going to do this investigation. And what would you expect as a reasonable in trying to approach both sides of this so that we can come up with a balanced scheme? What investigation in so-called public records is disclosed? You as a lawyer, this case representing the defendant, what investigation would you want completed before you felt it was reasonable to expect you to file this post-conviction in terms of public records production?
Well, under a trial version of 300.2, this court had kind of divided the agencies into various tiers, and I would expect that anyone representing criminal and trial actions would need the records from the state attorney and all the law enforcement agencies involved, at a minimum.
So you would expect that to be completed before a petition would be expected to be filed. What about the situation where it turns out that some of the public records were not provided or displayed, and there is already a fledged petition, and now there's an allegation that there's a discovery of new relevant material in public records production after the filing of the initial petition. What should the rule be about allowing amendments if something is discovered in subsequent public records discovery?
The legislation doesn't contemplate amendments. I would think if the court were trying to do it, there should be a very high showing of relevancy and necessity. It shouldn't simply be, I believe there's no records in the Leon County Sheriff's Office.
I'm talking about after the eventual production and the discovery of something in there that would give rise, for instance, to a Brady claim or whatever. Should there be an amendment allowed if there's been something like that discovered afterwards?
Again, the legislation doesn't contemplate that. I would think that the judges will have to make a decision on a case-by-case basis whether this is something that the legislature would prefer under as a successive motion as opposed to an original. But if we ensure compliance from the beginning, then this circumstance won't occur. And I don't know that we should always assume that there will be records that will straggle in, because for the most part, these records that we end up litigating years over have no relevance whatsoever. And anything that is going to essentially delay the post-conviction process is going to have to be something that raises a reasonable likelihood of release, and not simply for the sake of completeness. Counsel would like to have records to know the correction officer who ever has contact with the defendant while he was incarcerated.
Let me finally to be sure that we have it here that is clear. When is it that the state is representing now that it feels that it would be obligated, despite the previous statutory scheme and our decision in total? When is it that the state says now the triggering of its obligation to open up its records would occur in the state's representation to it now?
Well, the following statute, the schedule that the statute sets forth for the disclosure of records is the schedule that we will follow.
What's that date? When is that event or that date that the state says, now we have to open up our records, the state attorney's office, the police agencies, and all the others? When will that occur now?
Okay, I believe the prosecution does it within 60 days of imposition of the death sentence. And by this point, the prosecution is also going to notify all the law enforcement agencies involved in the case.
What about the exempt records? What's the records and exempt?
I believe that I defer to the actual wording of the statute, but they would be required to be submitted to an informal exemption claim within that time period as well.
Well, is the state still claiming an exemption for, as we ruled in total, that would not end until the end of the appeal? Until the appeal became final. When would it occur now under the state's view?
Well, the state will have other exemptions unrelated to the claimant.
You did say earlier this hour that you would have to construe the exemption that you now have to mean you have to produce those records that wouldn't have to be produced for after the appeal within the 60-day period.
Yes, that's correct.
I'm going to ask another question about the pulling of the deadline set in the legislation. The legislation does not give the court any discretion about the pull of the deadline. Is that correct?
That's correct.
What if enters quit and destroyed a lawyer's office, and he was preparing a fully fledged motion in post-conviction release, and there would be no provision then for pulling of the deadline for him to recapture the record and start over again?
Well, yeah, that would be something that would be litigated on a case-by-case basis.
But the statute is very clear that there is no pulling And so you're saying that regardless of what the statute says, the court still has discretion in granting an extension to ensure that manifest justice is done.
Well, possibly as part of your rules, you could consider whether acts of God or something could act upon the deadlines which are set forth in the
What about a fire?
That would probably fall in the same category.
An act of God, if it wasn't by lightning?
I'm not so exactly. Anything involving the elements.
What if the attorney died and the new attorney had to be appointed? That's an act of God.
Often to acknowledge, you've been at the bench for years, and you've heard a lot of parties argue to you that the plain meaning of a rule, or the seemingly plain meaning of a rule or statute, just can't possibly mean that it seems to say within the context of the case. So you'll hear that again.
But I don't know that there's much doubt about the plain meaning of that statute. That section.
It's not contemplated that there would be exceptions to the following times, but I think impossibility in the circumstances could be taken up.
And we would then not have been able, under this circumstance, to hold the filing of these when the legislature takes up the CCIs, and that had to take place before people could get back up. We would not, under this statute, have been able to have granted a polling of that, and these people would not be able to present their claims to the court. Is that correct?
Well, technically, this does not have a polling power for the court, and I would note now that we've been more commission recommendations. It was represented earlier that allegedly some defendants represented by legislative counsel had lost their federal time. That's not true. There's no federal court which has so far failed to entertain and claim on behalf of the court a petitioner based on the inability to file prior to filing deadlines.
There's a different way we keep these serious statutes of limitations, except the statute of repose. Exactly what are they usually?
This statute of limitations, we made one alternative reference to the code which we could have edited out. But statute of limitations is a construction that the statutory time comes forward and then this court still has permissible for the legislature to do that.
My concern is that with this inflexibility, and so while the court could still have equitable powers, that you got a situation within 2 days late. The judge dismisses it on the motion of the Attorney General. It then comes up here. Aren't we, again, building in by the very purpose of the inflexibility, which is to reduce delays, aren't we by creating more these inflexible requirements, not only potentially impacting due process, but again, actually causing more delays? And I give as examples, and I want to, as some had mentioned, I've written on it and other justices, the delay that I've seen up here, the biggest delay has been after the evidentiary hearing. And it's a delay is a year, 2 years, 3 years, 4 years. Where the board to the clear to give an evidentiary hearing unless the records conclusively refuted. But over and over again, with denying evidentiary hearings and the request of the Attorney General's office, and we have there 3 or 4 years to do. So my concern is we'll take someone 2 days late, and that will turn into another 2 year delay. So it doesn't have to be some sensibility in this, and trained people that are on both sides and the trial court that can really make cases move along without imposing inflexible requirements that have the potential for denying rights as well as causing delay.
So one of the biggest cases involving death penalty habeas corpus trials, Lloyd versus area, I think it is. Coleman v. Wisconsin, it came from Virginia. And the U.S. Supreme Court upheld the Virginia Supreme Court signing a procedural bar because the defense counsel was underweight in filing his state petition. And it may seem like a harsh result, but it's one that obviously the U.S. Supreme Court conceded could be done constitutionally.
Was there an opportunity to explain the reason for the bar?
I don't recall from the second time.
And was it determined that it was military, Congress and the public?
No, I think in all likelihood it was common. I forget how it might be. I haven't read it recently, but I do know those are the factual circumstances.
One of the ways the system can work is if there are adequate resources. Your office has requested how much in the way of additional resources in order to be able to respond to what could be a doubling of post-conviction motions at a much earlier stage. Have you calculated what that additional manpower, womanpower, people power would be?
Like Ms. Carter, I'm not really involved in the budgetary topics in my office, but I can tell you that the legislature is one house is offering $5.8 million to the register to see if the counsel will be afforded to these individuals. And Mr. Moss has written up a letter that will file with this court indicating that there are 122 attorneys on the registry presently, even without any additional being hired due to that funding to represent the inmates on death row. And obviously, as we pointed out, the legislative process is beginning, and certainly the trial counsel and the acting federal defender can supplement whatever budgetary requests they already have.
But won't it also require more judicial power? Resources?
Yeah, the judicial system arguably would, because it would have the processing of post-conviction cases which would not otherwise be filed. On the other hand, all the other cases already exist. We're simply going to dispose of them faster. And to some extent, by cutting down on supportive motions and by requiring more rigorous filings, there may be more judicial time available for the cases which are actually filed.
There are some legislators here that will be talking probably in the next section, but now it's conversation with the chief judges, every time we set time limits up here, this something has to be done in the trial court. It generally creates chaos, and I think our rule is that unless the chief justice has an extension, and I just continually get requests for extension because the unavailability of the state, or the unavailability of the defense, the unavailability of time on the judge's calendar. And these are just logistical problems that, and I know we've recently had a case scheduled for oral argument on this calendar for 4 different times, 3 extensions, I think, at the request of the state. And those, that's not faulting anyone, but that's just the whole reality of life. 32 years on the bench, I know that it's very difficult to get all the players together at a central time. And if we are required to set time limits and ensure that they cannot be breached, we're going to have to have a lot more resources from the state, from the defense, and also for the court, and the court support. And I don't know that we can get those figures. We've gone through a long extension of developing a new means of developing a case loading system, because we did not factor in these issues when we made our certification to the legislature. So how can we address that?
That's really beyond my expertise, and maybe speakers later in the day who would be better off to discuss that. But we'd like to say that the thing that we're coming down to is kind of the essential tension, ambiguity of defendants by their itself, because we attack the final criminal convictions, but as this court has said, it's kind of quasi civil. Now, if it were a criminal prosecution where the state was the moving party, and the state didn't move fast enough, then the statute of limitations would run, and the trial would run, and the prosecutor would be hired. But here we have a circumstance where this is initiated by the defendant, who traditionally doesn't really want to litigate because as soon as he litigates and loses, then the paper becomes execution. So we have a system that is different from most of the other ones before the legal system, and it's one that we try to contain and channel and progress. And I guess the point that both the American Commission and the legislature reached is it's only when you have absolute deadlines without exception that they're going to have these cases proceed. Because I think once the defense counsel realizes that they're really going to file this motion by this day, it'll be filed. If they think there's some wiggle room and they don't necessarily have to, they'll take advantage of that. I'm not. But if it's so much human nature,
if it's a reasonable deadline, and one of the questions I was going to ask is right now the statute requires the clerk to provide a record on appeal within 60 days of appointment of post-conviction counsel with a 30-day extension for extraordinary circumstances, and that would make it a record being 75 days after. Can you give us an estimate of how many transcripts are prepared within 75 days of the sentencing case?
I was very interested in that statistic and wondered if the court reporters union had been in contact with the legislature, but I do know that when we do get policy litigation, get law litigation, we traditionally have it hour by hour done. We have transcripts ready within hours.
Yeah, real time.
But that's really a recent innovation, and that's also very expensive.
No, I mean,
Isn't it going to have to, in order for us to keep up the filing of the record, I don't know what our time is now, but it takes a long time for us to get a record on appeal from the task force.
And if it takes,
we need resources to pay for real-time reporting.
I would assume the legislature is aware of that in shortening the time frame.
well, what the concern is that if the transcript takes more than the time that you have to file the post-conviction motion, once again you have a inability of post-conviction counsel to do anything about it, and it becomes essential that someone's going to have to mandate that these transcripts be filed within the 75 days. And I guess my experience was, even at the Fourth District, is that it was appalling the delay in filing transcripts. That's huge.
So again, we're here for a number of reasons. Essentially, we're here on the constitutional ground to discuss is that we're really here to discuss how we think the process should and can work. And as it says, there will be years to implement the legislature's intent, and certainly your Honor's experience will be critical.
If you agree that there can't be an intelligent motion filed unless you've got the record on appeal, and you need to have it at least for a couple of months before you can be able to do the work that you say needs to be done before the fully fledged motion to be
I was
filed.
confronted with a student from my opponent indicating he couldn't file his case because he didn't have the record. I was trying to leave the pleading on his side.
Does the state see any problem with dual charges? Or is it?
Well, I think there probably will be some logistical difficulties in the beginning, but there's no constitutional defect, and it is presently used not only in Texas, but in Virginia and Oklahoma, and to my knowledge, which would result in those states. Are you sure about Virginia? I was just advised by my personal knowledge.
I understand that the motion does not have to be filed until after the appeal, but I'm sure that means the post-conviction counsel is appointed while the appeal is in process.
Yes, sir. I was rather special edition from that.
But doesn't the state counsel in some compromise these traditions at times?
No, I don't see that for one. Most of what our opponents talk about were the situation of the pipeline cases where the circumstances we're complaining about are not going to happen. But certainly within the post-conviction ones, the roles of the various counsel are well defined. The competency of the appellate counsel is not challenged for after the appeal. I don't see a run-in between the post-conviction counsel and the appellate counsel. And this bureaucrat, just like some of the next commission recommendations are all designed to start the trial process early. And I can see on anything that we think has to be done that way. And the legislature found that as a faction that they thought would be most efficient to do that, and it was their prerogative to do that.
How do you think other states moved away from it that it's tried?
Well, so far we've really just heard that two of a number of cases that number of states have experienced it. To do that, I really don't know that. I do know obviously that the other states prosecuted and held to the California President of problems, it's not due to the nature of the conviction itself, it's simply due to a stopping problem of getting counsel, which is definitely not a problem in Florida.
Do you contemplate that the order on the evidence in here or the order on the post-conviction would be entered before the final appeal would be disposed of?
It can be that it's how big a variation.
Because what I'm thinking is that as far as this course review, one of the advantages would be if we could review the case together. Rather, now we've got one appeal of the first counsel and we've got a second appeal. Is there any mechanism where it has been considered? Because now, under the new statute, the ineffective assistance of the appellate counsel is at a different time. So theoretically, we're looking at the case at the summary denial stage, number one, at the evidence in hearing stage two, what's appeal three, ineffective four different times.
We should be familiar with it. I mean, at the moment, that's kind of the problem here, is the case takes so long to get anywhere that it becomes clear by the time you see it. I mean, you'll resolve the appeal in 87, you'll see the post-conviction appeal in 94, you'll see a very stage radius in 97, and you'll see definite litigation in 2005. So, and that really is the problem, and that's the excuses. But I do know that in the states that have it, I believe they do almost always address this in the court. I don't know if it's a file from the court, so I suspect that either formally or informally they consider the cases together, and they usually release the opinions together and investigate the on the file.
They do consider them together.
Also, either officially or not, but they usually the two opinions will come out and within days of each other, so that's the instance to say.
Okay, thank you.
Thank you, sir.
We'll take a recess on these vacancies reset. And we will begin with the consideration of the formal procedure rules.